A very warm welcome to this, the sixth lesson of our series on the law of evidence. In today's lesson, we will talk about the appreciation of evidence. Talking about the appreciation of evidence, we know that the stage of appreciation is reached after the relevancy and the admissibility of evidence has been assessed. So what is appreciation? Well, appreciation is the application of judicial mind, the judicial wisdom, to decide as to what can be inferred from the evidence. So you have some admissible evidence, and like I said, admissibility implies relevancy. We learned this in the previous lesson, which means that if I refer to evidence as admissible, it means it is also relevant. So therefore there is no need to say relevant and admissible. If I say admissible evidence, it's enough. So the application of the judicial mind to draw some inferences and conclusions and to judge the weight of the evidence is what the process of appreciation is. As we know, this is something that is done by the wisdom of the court. Well, before talking about judicial wisdom, I would like to talk a bit about wisdom as such. Have a look at this quote. Let me talk a little more about wisdom. Talking about wisdom and judicial wisdom, I decided to take this quote a little seriously. So I will not teach a lot in this video. In fact, I will not talk a lot. I'll keep this video really short. Instead, I will show you little excerpts of text. So make sure you pause the video at that time and read them. And I think this short lesson should be done quite quickly. Let us quickly have a look at the stages that precede the stage of appreciation of evidence. Obviously, we start off with the fact, and the fact is presented through a piece of evidence. Okay, so we first check whether the fact is disputed and relevant, because if it is not, then in that case we go no further. Suppose it is disputed and it is relevant, then we also check some rules relating to admissibility. Suppose it satisfies all of these, then we get to the stage of appreciation of evidence. We're all perhaps familiar with such phrases. These phrases in fact reflect the judicial wisdom in action. For example, when you talk of the satisfaction of the court, what is the satisfaction of the court? It is the satisfaction of the judicial wisdom. Likewise, when you say something has to be proven beyond all reasonable doubt, the doubt of whom? It is the doubt of the court. Likewise, when the court says that it finds an accused guilty, it means it is the finding of the court based upon the application of its own wisdom. Likewise, when you've seen a quote such as this, where a judgment reads that we are unable to concur with this decision of another court, it basically means there's a clash of judicial wisdom. So these are some instances of how you see judicial wisdom. Now let's talk about judicial wisdom in terms of appreciation of evidence. You see, appreciation is a matter of experience and knowledge of human affairs. That sounds like common sense, right? So I would like you to have a look at this little video relating to section 114. Perhaps you can see it now or you can see it later. Section 114 in fact is my favorite section in the entire Evidence Act. It is one of the very few provisions that relates to appreciation of evidence, and it embodies the rule and the principle that common sense requires to be considered at all times. You cannot ignore common sense when you're applying the law. Anyway, I'll talk a little more about appreciation of evidence. It says that appreciation is a delicate task which is to be carried out by judges who weigh the evidence and draw inferences. You might remember that I said that the reliability of evidence is spoken of in terms of its weight. Okay, and there are peculiarities in every case is different, and it requires that common sense and dexterity be shown and displayed by the judges. Okay, fair. So we understand that appreciation is a matter which is very subjective, and therefore it is required that the judges carefully dispense this duty while also applying common sense. Okay, let's go a little further. You see, the Indian Evidence Act deals almost entirely only with relevancy and admissibility. You do not find many provisions relating to appreciation. Section 114 is one of those few sections that deal with appreciation, but largely the Indian Evidence Act deals with admissibility of evidence, right? It only talks about what kind of evidence can be tabled before the judge. It does not talk about how he should decide its reliability and so on, right? This might beg the question that why can't these matters of wisdom and common sense and dexterity be penned down? When you can write down the rules of relevancy, you see, we saw that the rules of relevancy are after all rules of logic. When you can write these down, why can't you write down these matters of wisdom as well? Why can't you codify them? Why have these been left to the judge? As we can see, the judge has been given the discretion to exercise his wisdom. So one of the ways of saying it is that a lot of confidence has been reposed in the wisdom of the judge instead of simply allowing that to be determined by the dead black letters of the law, right? And also, appreciation involves the assessment of worth, value, quality, and perhaps it has been felt that the judicial mind is more adept at doing it than perhaps some bold letter of the law. Having said that, it is important to know that this power is not limitless or unfettered, right? There are some checks and there are some guidelines. So you see, it's not something that is based only on his mere intuition or discretion. There are rules that govern this, right? So there are various principles that have been evolved through various cases. Judges are trained to learn how to appreciate evidence, and there are practices in the court. So the judges do have to conform to all of these rules. However, it must be known that the Indian Evidence Act does not speak so much about appreciation, yet there do exist a lot of guidelines relating to evidence. You remember that the law of evidence is much wider than simply the Indian Evidence Act. So the rules of appreciation can be found in judgments, can be found in some of the rules, in some of the directions that are given by the higher courts to the lower courts, and so on. At this point, I'd like you to pause the video and read these beautiful lines written by Justice Cardozo. Let us say we are at the trial where A is charged with the murder of B. Okay? So as we know, the main question here is before the court, did A kill B? This is the main question, right? But sometimes you don't have the answer to the main question directly. Instead, you have to rely on some other things. For example, what was the location of A? Was he at the place where B died on the day that he died? Or perhaps you might need to know as to whether there was any enmity between these two, right? Was he in possession of any weapons? You see, so these are some related facts. Now, each of these facts might be disputed. So A might say that he was not there, whereas the prosecutor might say that he was there. Okay, for example, here for the enmity, A might say that there was no enmity, the prosecutor might say there was enmity, and so on. So each one of these facts could be disputed, they could be relevant, and so the process of the trial involves each one of these questions here. So you first pick one fact, okay, check its relevancy, then you check the admissibility of the evidence presented, and then the evidence is appreciated. That is done for each fact, like say for fact number 1, then it is done for fact number 2, it is done for fact number 3, and so on. So for each fact, you subject it to this test of relevancy, admissibility, then you appreciate it, and then you decide on the basis of that whether the fact 1 exists or does not exist, right? So you first check, is it relevant, is it admissible? Thereafter the judge applies his mind to it. And then he decides that okay, either A was there or A was not there. Likewise, he might decide that whether there was enmity or whether there was no enmity. He might decide whether there was possession of weapons or no possession of weapons. That's what happens after the appreciation of evidence. Summing up today's lesson, we first obviously start with a certain fact. That fact is presented through a piece of evidence. We see whether the fact is relevant or not. In case it is relevant, then we check whether there's any rule of admissibility that bars it. In case it is not barred, then we go to the next stage of appreciation. After the appreciation of evidence, the court would either believe that this fact exists or does not exist, which means the court will ultimately determine whether the fact is proved, disproved or not proved. These terms, proved, disproved and not proved, have been discussed in this video, which you can access by clicking the I button here. Okay, so it is decided as to what happens to the fact. Then this process is repeated with all other facts, and then finally the dispute is decided. As promised, this was a short lesson. I hope it was of worth to you. Thank you for your patience. Good day.